Hello, I'm Attorney Dan Marr from the New Hampshire law firm of Hamlin Kerrigan here in Nashua, and I've been practicing here for about 39 or 38 years and about 28 years in the Commonwealth of Massachusetts. I'm going to be talking today about how you can help your children in regards to your estate plan, basically, particularly as to preventing them from making mistakes and preventing them from being taken advantage of by somebody. So I'm going to be talking about a variety of issues. One of the things that we deal with in estate plans is our trust estates department is they certainly encourage what's called a revocable trust, and the revocable trust is something that's just like a will. A person, as long as they're competent and they're alive, they can change it anytime they want, and they can put anything in it and take anything out that they want, and they can change the beneficiaries that they want. So it's just like a will, but upon death, when they've transferred the assets into the trust during their lifetime, it goes without a probate process, and you have the ability to actually spread out the assets to your children or others over time. And I've talked in other vlogs before about the idea of some people will do 30, 35, and 40-year-old for disbursements to the kids with some discretionary disbursements before for the trustee. And the idea is an 18-year-old is probably going to blow the money, and if you just have a will at 18, they have a good chance of getting a good portion of those assets. But you might also, in regards to some issues that you want to protect them from, if you have the benefit of the trust, so you have everything in the trust and not in just a will, you can have the trustee make some discretionary decisions as to not providing for them if they're having marital issues. If they're having there could be a setup, and you'll talk directly to your trust and estates people, and we have two very good lawyers here that do those work. But the discretionary issues of the trustee, if the trustee has some discretion, maybe they're not going to be making a disbursement if the person's going through a divorce. Maybe it's very clear that this is not an asset of that person for a marital split of assets. You have to state certain language and deal with those issues, but our trust and estates department addresses those issues regularly. What if the child is having a drug issue? Unfortunately, that is a reality out here now, and they might be in needs of help, but not getting a disbursement because, frankly, they might blow it, or you might kill them because they have enough money to really make some stupid decisions and kill themselves. So that's a very serious, obviously, issue. But sometimes you want that discretion with the trustee to make those decisions to help them help themselves, and also, again, they might have a bad or a potential for a bad breakup in a marital situation. You don't want the estranged ex-spouse getting half of the inheritance that was meant for your child. So you want to address that. We also address the issue of siblings sometimes not getting along. I do a lot of the litigation in trust and estates, and usually it's the last of the two of you, if you're a married couple, to die, that one of the children might turn on the others. They usually rally for the others, and particularly since your normal situation is what we call I love you wills or trusts, where everything goes to the surviving spouse, meaning mom or dad, and then when mom or dad dies, so that both parents are gone, the kids are fighting. So that's usually happens. I've seen it situations where they actually don't wait and they start fighting with each other beforehand, but most of the circumstances that's the case. If you're in that situation, you want the estate plan, you want to think carefully about if you think that it's going to be a risk, an interim clause. In New Hampshire, that's a no contest clause. It's enforceable in New Hampshire. Massachusetts, there's a little more of flexibility with the courts in dealing with, but generally in New Hampshire, they'll enforce it. If you're challenging the will of the trust or the will of the trust and you lose on that, you get nothing. If that's what the agreement says, the provision says, then it's going to be enforced. There's provisions there that prevent people from a trustee from taking advantage, embezzling, and then saying, well, wait a minute, you're contesting this, so I'm going to be challenging you on that issue. You made a challenge, and even if you're wrong, I'm going to get that. The courts are going to have a tough time with that. But the idea of you're saying to you're challenging that mom or dad was incompetent or unduly influenced, meaning that one of the other children manipulated them into making this distribution, and you lose on that, you lose everything. So what you want to do in that situation for that child, if you think that's going to happen, even if you think that child you paid, you might be in a situation where you say you have 3 children, and you're doing even distributions of a third each. Well, then that's pretty enforceable, that the person loses the 1/3. But if you have that child and you think he's going to cause trouble or she's going to cause trouble, and you've been loaning them or giving them money all their life, and you're thinking that the reality of the matter is they're not going to bother, they have nothing to lose but to fight this, put something into the will to lose. Say you have a $1 million estate or $3 million estate, put $50,000 or $60,000 in there. So then for that child. And then if he challenges, he's got real skin in the game. He's going to lose $60,000. Not only is he going to pay his attorney's fees, but he's going to lose $60,000, $50,000. And the other children will be better off for it too, because they won't have to fight with their sibling. And even though they may not get great relationships with their sibling, once that child makes some allegations of improprieties by their siblings, even though they did nothing wrong, you can't unscramble that egg. And it's going to be tough at weddings and other funerals to deal with those issues. So you may want to think carefully about cutting them off at the pass and putting an interim clause in. I'm attorney Dan Marr at Hamlin Carrigan. I've been, again, practicing for quite a few years and happy to discuss any of these issues with you. I'm at 603-883-5501, 603-883-5501. And our website is NashuaLaw.com, and you can look at my vlogs on a variety of topics. They're weekly vlogs, so there's quite a bit of them. And I'm happy to help you if the opportunity arises. And our estate planning department is excellent. We have great lawyers and paralegals, and they can help you with a variety of different issues. Look forward to working with you if the opportunity arises. Thank you.